to our webinar. Uh, we're excited to have such a great turnout today and to be joined by Professor Philipp Hacker as we explore the fast evolving world of AI regulations. I don't know if you know me, but my name's James Herron and I'm the head of growth marketing at Vendict. And with experts from tech, GRC, legal and academia in our room today, we're driving into what recent regulations mean for the future of AI. And Philip here is our leading expert who has advised the EU Parliament in the AI Act, which help us navigate the key challenges around AI's growing role. We'll be asking him a few poll questions and you a few poll questions throughout and opening the floor for your questions as well. So you can engage with Philip on the issues that matter most to you. One of Philip's latest papers addresses AI's most pressing challenges today, which is transparency. Explaining how models like GPT-4 make decisions is no small feat. While the EU AI Act doesn't currently push for strong transparency rules, existing laws like GDPR already require companies to disclose AI-driven decision-making. So it gets even more interesting that just last week, the US and the UK declined to sign an international AI agreement in the Paris Summit. The US decision reflects its broader anti-regulation stance, while the UK's reluctance is largely shaped more around Brexit and UK GDPR rules, and a desire for control over AI governance. So in short, this really highlights two competing approaches, the EU's regulation first model and a competing innovation focused stance with minimal government interference. It's going to be an insightful discussion today. So with the scene set, I'll hand over to Philip to take it away. We will dive deeper with a Q&A afterwards, and we'll have to explore these topics further with Philip. So Philip, over to you.
Well, thanks, James. Thanks, first of all, for having me here. This is a wonderful setting. I'm excited to see so many folks online, and great, very warm welcome from my end as well, from Berlin here. I'm going to share a couple of slides and start us off with I can't even say deep dive, but just some thoughts for setting the scene on the challenge of transparency, particularly with respect to generative AI. Because if you think of some of the main opportunities, but also the challenges in generative AI and in using these fascinating technologies and tools down the road, I think one of the key concerns that we're seeing, and when I talk to industry and to regulators, is the lack of transparency, is opacity. And we will discuss several aspects of transparency, different dimensions of them, and how they square with the legal environment and what can be done perhaps also in the legal environment to squeak or to turn the legal environment to be more proactively engaged with the latest turn of events in technology. So let me start you off with just a very simple example so that we can have something on our minds to deal with. Let's say a company wants to hire an engineer. And to do that, because they expect to be flooded with CVs and applications, they use an LLM-based hiring system. What does that mean? So basically, from a technical perspective, it takes 3 steps. First, you need to extract information from the job description, basically the posting that the company is doing. So extract the key requirements or whatever kind of skill sets are needed for that job, for example, that engineering job. Then, on the other hand, you take the resumes that come in and screen them, again, extracting the key information and matching in an embedding space, basically within a large space of information. You match that information from the job description with the resume information. And then out of these different matches, you try to generate, and that's a third step, a ranking between the candidates with something like a candidate fit score, basically how well does a candidate fit the job description. Sounds pretty easy. And you could ask, what could possibly go wrong? And there's a smiley behind it, of course, because I'm asking this question a little bit ironically, as I have been working on questions of intransparency, discrimination, and so on for quite some time in the AI space. And many of you will know that, of course, there is a number of things that can go wrong. Now, if we think more broadly about responsible generative AI, here are, I think, 4 key pillars that we need to keep in mind in terms of things that could go wrong. One is that the EU AI Act, as probably most of you know, is starting to kick in. Most of the rules will only be actually available, or will only be applicable from August 2026 on, but already some rules and prohibitions are in place in the AI literacy requirements. Then we have data protection law with its own transparency requirements, and there are transparency requirements in the EU AI Act as well. We have copyright law, which again has some transparency requirements of its own and is a different source of litigation, and also connected deeply with the AI Act. And it's one of the big questions now for the code of practice that is being discussed at the European level very heavily. And then finally, there's always this, I'd say, risk of liability if something goes wrong and somebody feels harmed. Now, I just want to stress that this looks like a lot of regulation, and certainly there's even more to it. But I'm firmly convinced that if you are in a company and you partner with a good legal partner, this is all manageable. But you have to take it seriously. You have to take it seriously from the start so that you kind of design compliance into your products, and you don't go to some kind of legal office or your partner or whatever and tell them, look, here's my product, please sign off on it. That's not going to work. That's not going to work with the AI Act. That's not going to work with the GDPR. But otherwise, I think this is all manageable. However, there are significant challenges, particularly when it comes to the use of generative AI. As you know, generative AI in the kind of autoregressive LLMs that we have at the moment is prone to hallucinations. For example, a colleague of mine at the University of Georgetown, a law professor, was accused of sexual harassment by ChatGPT. And this is something that's tough to get off your online record once it's out there in the world, as you know. Is that a legal problem? Well, perhaps. We have a pretty active NGO in Europe. It's called No YB, None of Your Business, and they actually are suing OpenAI because of hallucinations. And why is that a problem in data protection law? Well, the GDPR says it has a principle that says data needs to be accurate. And so if the ChatGPT or another language model says something that's inaccurate about a specific person, that might be a problem with data accuracy principle. I say might because I have some specific thoughts on this. I'm happy to dig into this more concretely, and I don't think that every incorrect statement actually is a violation of that principle. But you can see that there are some legal questions around this. Of course, really in the news in the last couple of days has been the up-and-coming Chinese DeepSeek surprise, with first on the technical side, of course, the many revelations that have come through this new model, the kind of ingenious ways in which the Chinese engineers have used reinforcement learning to cut a couple of corners and develop a model that's very slick and very highly performative. But at the same time, the app, so if you use it via an API and if you use the app, is of course taking and transferring the data to China, and nobody really knows what's happening with it, which is why Italy's regulator, the data protection regulator, has now blocked DeepSeek from the Italian market. And that, please note, is not the open source model that you can run locally on your device, but it's the app and the API that is affected by it. And the same holds true just, I think this was 3 days ago, by South Korea, which equally has moved against DeepSeek over privacy concerns. So we see that there is this regulatory stance that comes from often data protection law, while at the same time, of course, it is a good moment, and it's certainly a necessary moment to also think about AI adoption for a lot of companies, as the US is gearing up for Stargate, whatever will come out of it. So far, the 500 billion certainly have not been collected, and we'll see if they ever materialize. The EU has answered with an initiative of its own, the Invest AI initiative, mobilizing 200 billion euros, or seeking to mobilize 200 billion euros. This is certainly something I'm really happy to see, because for years, actually, I've been saying that we need regulations for responsible AI, but we also need to make sure to tell people that, yes, even in the EU, we want and we need AI, and we desperately need it, and we want to see more of it. But if it's rolled out in a responsible way. So this leaves us with a number of questions, I think, concerning the right way to development and adoption of AI, and I'm really looking forward to the discussion with you. Let's start the debate.
So thanks for the intro, Philip. I think one of the things that we can start with really is we spoke there about transparency. So what makes transparency in generative AI so tricky? And are the challenges technical, or do legal and business factors play a role too? How do you see it?
Yeah. So by the way, I just see this poll. This is really cool. Can all other people see this too?
Yes, this poll's
Yeah.
going.
Okay, that's cool. Yeah. Technology is too complex. Companies don't want to share. Laws are unclear. All of you. It's probably right. So I think there is probably three different answers to it, and you're getting it pretty right here. So on the one hand, there is a clear technical difficulty that's even more pronounced in generative AI than in other AI models. And when I speak to my engineering friends and people who are really experts in XAI, like we have research teams here at Technical University Berlin who are world leaders in it, they do confirm this. And this is due to, I think, three particular parameters or three particular aspects. The first is that it's extremely highly dimensional, right? So these models are very complex. With traditional AI models, you have perhaps you might have a couple of million, features. Now, with these, you have data points, you have parameters that go into the billions or even trillions. And that makes it highly untractable for traditional methods of ex post explanations. Because even, your deep neural networks that you use for image recognition, for example, they're very hard to explain. But what is being done is you do some sensitivity analysis. So basically, you try to perturb the inputs. You look at, well, if you shift that nose a little bit to the left, does Philip now look like a criminal or not? And if that's the case, or if the eyebrow, does he look like smiling when he's whatever? You shift the input a little bit, and where you see a big shift on the output side, that tells you, well, very likely this is what's driving the output. Now try doing this with a couple of trillion parameters. You end up computing until the end of the universe. So it's highly inefficient. And there's a couple of other factors too. So, for example, users do interact with these systems, sometimes change them. And there's many more aspects to be taken into account with a generative AI system than with a traditional AI system. So you might want to ask, what's the right angle of transparency? Do I want to have transparency about the way the training data influences the output, or the model structure, or the decision process, or the prompts and the way in which they are structured and they are ordered? Or what causes the hallucination? So there's many more points to discuss technically than in a simple feature, feature mapping to output. Plus, as you mentioned, right, the legal side is also problematic because we just have very little case law on Article 15 of the GDPR, which is one of the key drivers of transparency there, and we have none, obviously, including no guidelines whatsoever on the AI Act, because it's just been, enacted. That's not a fault of the law. It's just a logical necessity, kind of, because it's just been there for half a year, even though, the guidelines, it could have been prepared a little bit earlier. And finally, yes, it's also a business decision because some companies make their models open source, and in a truly open source way in which you can inspect the weights and sometimes even the training data, whilst others keep it play cards close to their chest and use closed models. Hence, you know very little about what's happening behind the scenes. And that's the case both for OpenAI and for DeepSeek.
A really interesting breakdown, Philip, and it looks like the audience agree with you too, saying a mixture of all of the above, really. But I just think it's also quite interesting because you talk, as a marketer myself, we always say that marketing is 99% about timing. And I think that the industry is a reflection on the timing at the moment, where we find AI, where we find regulation, and how they are either trying to catch up with one another or coexist with one another in the best possible way. And we're seeing that not only across Europe, but across the US and in the UK as well. I just find it a very interesting time to be discussing how things impact, really.
Yeah, it's an incredible time to be alive, actually, if you're in the AI field. At the same time, things have gotten even more interesting since the Trump election, of course, and so we'll see where that deregulatory turn that is taking place in the US is taking the rest of the world. Certainly some impacts can be felt already, and we can dig into that a little bit deeper later on if you wish to.
Well, moving on a little bit, I guess, to the next question. If we look back at GDPR, which feels a very long time ago, I guess time flies when we're having fun, right? But if you look at GDPR versus the AI Act, which one actually has more teeth, in your opinion, when it comes to specifically transparency?
Yeah, that's a good question. I think the answer is simplest for now because the transparency provisions of the AI Act do not even apply yet. But that's too simple an answer because companies are already starting to prepare for it. And rightly so, because if you're a general purpose AI provider, or you are potentially becoming a general purpose AI provider, note that under the AI Act, even if you're a mere user, if you fine tune a model or you change it significantly, you might become a provider of a general purpose AI model. And by GPAI model, I mean, like, this is generative AI, for example, like foundation model. And those rules kick in August 2025. So basically, if you want to be compliant, you better start now. And the high risk rules then kick in August 2026. So again, not a lot of time to update your systems. Mm-hmm. Now, still, I think that the interesting fact is that what we're seeing right now is a lot of enforcement activity on the GDPR and generally data protection rules around the world, and particularly also in the EU. So I think that at the moment, it's fairly safe to say that GDPR is actually having a larger effect. Perhaps also because the enforcement authorities, they have already been there for quite some time, and they are kind of experienced and know which triggers where to pull. DeepSeek was blocked not because of the AI Act or not because of any other laws, but because of the GDPR. Same, by the way, with the ChatGPT when it was blocked again, also by Italy back in, I think, 2023. Yes. Interesting. OpenAI was just fined 15 million by the Italian Data Protection Authority. Actually, that was the proceeding under which ChatGPT was temporarily blocked in 2023, and is now evolved into a 50 million euro fine. Which for OpenAI perhaps not a lot of money, but it shows that this can be significant. At the same time, I don't want to scare people off. I mean, the data protection authorities, they're going after the big guys at the beginning, right? Because that's where they're having most impact. And I think if you're a small company using a Gen AI model, and you're doing, you're showing good efforts to make this transparent and to be compliant, I think there's not a big chance you're going to be, dragged to court right away. But at the same time, this is something to be taken seriously. And of course, as the AI Act then kicks in, we might see more cases from the AI Act coming out. Note that even in the US, there are data protection cases. So recently I've seen that LinkedIn was actually sued under a California and a federal statute because they used customer data, user data, people like you and me, I guess, James, for LLM training, for AI training. And they didn't really make this very transparent. Nonetheless, people found out about it. And this is something that even in the US can create legal problems. So it's something you want to be transparent about. You want to, be sure to have that in your privacy policy and to do this in a way that, takes your customers along and somehow, if possible, gets their consent.
Great answer. Really, and I didn't know specifically about that it was GDPR that was putting down the issues with I guess all of the recent issues that are coming up. It's interesting that how it's being used, because on the business side, this is not something that we're so au fait to, but obviously you are, and really interesting to hear. Just diving a little bit deeper into that. So you're saying that GDPR is really being confidently used now, and as a law and regulation, we know how that is working. So do you see the EU AI Act being added as another layer, or do you see it changing things significantly? How do you see it working, I guess, if it's right to say, alongside
It's another, but it's a different layer. Why that? Because the AI Act mainly has the most stringent rules, which, by the way, are not so stringent at all. It's mainly industry standards that are rolled out. If you're a high-risk provider or a GPI provider, you basically have to, by law now, adhere to industry standards that have been best practice for quite some time if you've been in this field. So it is a new layer, particularly because it looks at the providers mostly. But the providers, those are basically the developers usually, those are not necessarily the ones targeted by the GDPR. The GDPR in first instance targets the user, because the user is actually, is doing some of the customer data, even if the program, the app, the AI system that the user uses, the professional user, was developed by some other company. So, for example, if I use ChatGPT, which was developed by OpenAI, and I put in customer data, then I am the one that is doing this data processing. Now, some of this I might be shared controller with, it gets a little bit tricky. OpenAI might also have a share in this if this gets sent to the cloud and so on. But primarily, I'm doing this, I'm typing this in, right? So the GDPR targets more the downstream, whilst the AI Act targets more the upstream participants, which also creates a kind of disconnect, because often the questions are similar, but then you have different entities that are responsible for it. And at the same time, the AI Act, of course, is much broader, but it's also influenced by the GDPR and vice versa. So, for example, if you violate the AI Act, it's very likely that you also violate the GDPR, coincidentally, because then you do not have a legitimate interest in your data processing. Meaning, for example, you want to train a Gen AI model or any AI model, and you have a data trove, but that data trove is not very representative, and you want to do it for a high-risk use case under the GDPR, under the AI Act. In that case, Article 10 of the AI Act tells you your data needs to be a representative of the target group, needs to be somewhat, balanced, not only wise middle-aged guys like James and myself, which I think is a good thing to have, and standard data science practice, because otherwise you would perform very poorly, would generalize pretty poorly onto the general population. Now, if you still have a data set that's not really in line with Article 10, that means that under the GDPR, when the data protection authorities ask, did you have a legitimate interest in actually doing this processing, because you didn't have consent, perhaps because you couldn't ask all the 50 million people in your data set, then they're going to say no, because it is a data processing that's actually breaching the AI Act, and for illegal data processing, you never have a legitimate interest. So this connection is also really interesting, and which is why increasingly I think the compliance teams will need to integrate these two instruments. And we're also seeing, on the other hand, how the authorities are integrating and trying to integrate the data protection teams within the AI authorities, and vice versa.
Okay, a lot to go into. I feel like we could go into every topic far more in depth. Just a chance for me to say a bit of housekeeping. The chat is great. I see a lot of people talking to each other. I think, Philip, we might have tapped into your very engaged community, all here talking to each other from many different places around the world, which is really
excellent.
Cool.
Love that.
Just to remind the audience here, and there are many of you, I will get to the questions. Maybe we'll do one more question, and then we'll answer a couple of the audience questions. But there are polls also. So our moderators are sending out questions as we go through to get your understanding of how you see things from different perspectives too, right? We have a lot of different backgrounds, we have a lot of different nationalities and different views, so it's always great for us to see how things play out on a higher level. So thank you very much for answering those poll questions already, and if you haven't, great to get your opinion too. It really helps us understand a little bit about our audience here today, which we think is really critical, really important. So yeah, thank you very much for all of that engagement so far. I don't know whether you want to go, Philip, into talking about Article 15 or the OLA ruling more. You let me know, and we'll crack on with the next direction. Philip?
Yeah, I'm back. There seems to be
hello.
a glitch. I'm sorry.
No, it's okay. It's a slight internet connection might be the issue. I hope that everybody can see you.
Hope so too. Yeah.
Are you good?
I'm good.
Perfect.
Yeah.
So just wondering whether you want to talk more about Article 15 or you want to jump into the OLA ruling a little bit more, but we'll give you a fork in the road about which way you want to take this a little bit.
Yeah, I mean, we can combine that. So for those people who are somewhat familiar with the GDPR, you might know that there's a specific article, Article 15 of the GDPR, which says that basically, if you're a data subject, you can access the data that a controller holds about yourself. So in fact, this is what I do a lot of times when I go to the doctors, and I ask them, because I needed, I need some medical information and I need it for a different doctor. And then usually what doctors, or sometimes what some doctors do, is they tell me, yeah, sure, I'm going to give it to you, but you need it, I am charging you $20. I tell them, no. First copy is for free, says the GDPR, says now even the CJU. So life hack, tell them that you have a right for your free medical records under the GDPR. And I've gotten out of a number of fees with this. Sometimes it helps to mention that you're a data protection professor, but you can just say you're one, or you got this tip from a data protection professor. And so that's what you get. But then Article 15 has more. It says that in the cases of automated decision-making, and at least in those cases, so basically critical decisions, which are heavily influenced by data processing, by automated data processing. In these cases, you also have to disclose meaningful information about the logic involved. What does that mean? Nobody really knows, but people have been guessing about it. And there was a long discussion in academia about whether that amounts to a right to an explanation or not, or what kind of explanations are needed. And now we have the first court rulings coming up, and this is really exciting to see. So the key rulings are from the Netherlands now, in cases involving Uber and Ola. Ola is a different ride-hailing company. We don't have it in Germany, I think, but it seems to exist in the Netherlands, like Uber. And so the drivers got together, and this is also something we see. They were not suing under labor law, employment law, but rather under the GDPR, because the GDPR is pretty tough sometimes. And they said, hey, under this, we want to know how we are connected with the writers. Why is that person, given that writer and that text and that one? Plus, we also want to know why we get fired sometimes or badly, scored internally. And then as a response, the court said three things. And this is now already the appellate court in the city of Amsterdam. So already a little bit higher court. So it said, first, you need to disclose, as the user of the AI system, in that case, Uber or Ola, you need to disclose the factors that were taken into account in the decision-making process. And that means locally or individually. In technical terms, you would say local explanation. So basically, this means, well, this is the key factor in this specific question. And then there's a second requirement. You also have to give them the factors on average, basically on aggregate. How does the model work? That's called a global explanation. And third requirement, you have to give the information complete enough for the data subject to understand it, because the real idea of Article 15 is to say, now I got the data, and now I can think about whether I want to exercise a right of correction or a right to erasure or something, or a contestation. But for that, you need to be able to understand this. So that goes quite a long way. And if you think about Gen AI or other complex AI systems, it's quite hard. You can do these local explanations usually quite nicely in post, at least with traditional AI in post hoc explanations. but it's very hard to do this on a global level. Like, how does the LLM work in general? It's like, nobody really knows. You can do testing, empirical testing, and that's where this is heading to probably. And now the interesting thing is that this is shifting to the CJU. There's a case at the CJU, the CK case, and it has been rightly mentioned in the chat. There's a Schufa decision. Schufa decision is more about, what does it mean for a decision to be automated? And now the CK case, that is going to answer the question, what is meaningful information? At least we hope so. And the Advocate General, which is that's a person at the CJU, which prepares the decision for the judges. The judges can follow that opinion, but do not have to. But oftentimes they do. That person, the Attorney General, has just rendered his opinion and has gone along exactly the same tracks, actually, as the OLA court. So this is where I expect the decision to land. Also because it makes sense from a GDPR perspective. Article 15 is data subject rights, so it must be interpreted in a way such that the data subject is enabled to exercise their rights. And that, again, if you have a black box system, a fully black box system, that makes it kind of hard. And again, I think this is perhaps not for the worst because it sets incentives, legal incentives, to use interpretable or explainable AI. And that might even be better for the customers because they also know, why is this decision being taken this way, not another? Can we correct it? Maybe it's, this was taken for some stupid reasons, and hence it doesn't generalize to other cases. Maybe the system, the model was overfitting here, and so on and so forth. So I'm generally a big fan of explainable AI, and it's exciting to see that some of the techniques for explanations are now being brought on to generative AI systems, but we're only starting to see this. And yeah, in fact, if I may say one thing, I have a handbook coming out, Oxford Handbook for the Foundations and Regulation of Generative AI. And there we have a chapter by Professor Samek from Technical University of Berlin, who is one of the world leaders in the field, on precisely this, on XAI for Gen AI.
Interesting, and it would be great to get a signed copy. If I'm around Berlin for the book signing, would be good.
Sure, absolutely.
Let's take this opportunity halfway through. We'll get through some audience questions. We'll try and do a little bit of quick fire. So I'll try and get through 5 or 6 to answer quickly if we can, or with some, I guess, not one word answers, but let's see how we do. So Argiro says, do LLMs have the legal duty to tell the truth? I don't know if this is something that's theoretical or practical, but very interesting question.
That's a great question. There's an article by Sandra Wachter, a friend and colleague of mine, with precisely that title. And in fact, that goes to the hallucination issue, right? So on the one hand, if it's not personal data, there's very little that would make an LLM tell the truth, legally speaking, unless it is of concern to, let's say, the foundations of democracy, which is something you could say, for example, climate change, misinformation. This could be a systemic risk, and under Article 55 of the AI Act, if the model is big enough, so-called model with systemic risk, more than 10 to the power of 25 flops, or specifically designated by the Commission, such as perhaps DeepSeek might be the first model in which this actually comes on, then yes, you have to care about it. Otherwise, no, there's no legal duty. If it's personal data, then that's precisely the question. Under the data accuracy principle, my take on it is, if it's something that's not really relevant, like the LLM gets my birthday wrong, I'm saying like, well, I don't care. Actually, I'm quite happy for it to be wrong. Like I might be younger than I'm actually am. But fact being, if this is something that's really relevant, because I don't know, it's an eligibility criterion for a scholarship program, and I can't apply because the LLM got my birthday wrong, then yes. And so it always depends on the context. But generally, there's no general duty, but in a specific number of instances, there are duties.
Good answer. Very good answer. Next one we have from Georgiana. What is your opinion on the recent withdrawal by the European Commission of the proposed AI liability directive?
Oh, thanks for that question. I've just been to the European Parliament at the end of January for a hearing on the ALD. I've authored a report about it for the Parliament. And we were set to, actually, the European Parliament was set to engage with this in a very ambitious timeline over the next year to discuss whether it's needed. I think it's still needed, simply because what we have at the moment is the PLD, Product Liability Directive, which only concerns loss of life or physical integrity, loss of consumer data, and damage to consumer property. Nothing else. So any of the Gen AI harms, discrimination, personality rights, IP, professional IP, not covered. Which is why we might need the ALD. But now that's been withdrawn, there's two angles to this. One is, of course, it fits within the deregulatory flavor. So it might be the first result of Trump's election, that the commission is saying, hey, maybe we don't need that anymore. But also, there's a little bit of internal politics behind it, and that is not so nice. So I think there is no good reason not to have it, but it's been sacrificed on the altar of a few shady arguments. I think personally, the chances for seeing it revived are around 20%, not more.
Okay, very nice. I've got a really great question here from Iris. You will like this. Is responsible AI equivalent to transparent AI?
No, it's not. It's broader than that, which is why, and in that one slide that I showed you, I could have also mapped out responsible AI a little more concretely. So I think it's also, it has non-discrimination, certainly. It has certainly also quality controls. It has, you might say it has copyright adherence to it, because it's also a matter of fairness to the artists. And it certainly has, I would say, sustainability issues. So the question of, climate effects of the electricity consumption, something that's quite close to my heart that I've been doing a bit of research on recently. So it's broader than that, but transparency is one aspect of responsible AI.
Nice. Okay, so that makes it clear for me even. Perfect. I'm going to finish off this round very quickly from Agiro, who opens this up really nicely. A practical question for the professor, which I quite like the start of this. So what about AI components, small systems, a part of the bigger systems that are not intended to be used in specific use cases? So if in the future they will be used in an HR use case, they're obliged since the beginning to be compliant to HR AI systems provisions. It seems too strict for small, medium enterprises, etc. So I guess the feeling between larger companies, smaller companies, how relevant are they when moving between the two? Good question.
Excellent question. Two dimensions to this question. So one is, you have a component, maybe it's a small LLM like Llama 70B, or even a 7B model that's somewhere in a decisioning engine, and that is much more general. And then at one point it becomes used in a hiring process, and then it's high risk. So the thing in the AI Act is the entity that is using it for hiring is the one responsible then. That's a provider then of the high-risk AI system. That's the one that needs to ensure that the entire system, including this AI model, is compliant. So it's not the provider of so it's not Meta if it's Llama, or whatever Mistral if it's a Mixtral model or so. It's the user, let's say the professional user, which is called the deployer in the AI. So just to clarify that. Does that mean that the model needs to be compliant all the way? Well, it depends. The provider could say, you must never use it in a high-risk use case. And in that case, well, if you still use it, it's kind of it's your decision, your risk, but then you won't be compliant, and you're, as the deployer, you're going to be charged, but not the provider. Now, is that fair to SMEs? Well, yes, I think that, or no. I think, yes, that's a very good question, because the one major concern that I have, two major concerns with the AI. One is about SMEs, because even though a lot of this is just good industry practice, it still might be overwhelming to ensure that everything is according to the law for SMEs, particularly if you're a startup and you want to build a product, and then all of a sudden you have to hire 5 lawyers instead of 5 coders. I mean, that's not a good decision. So that is concerning. And I think going forward, this is precisely what the Commission is going to look at. Maybe later on we talk a little bit about future development of the AI. Second point that I find concerning about the AI Act is actually the narrative around it, which is a wrong narrative. The AI Act is much better than its reputation. As I've said, many of these rules are, use data that's appropriate and representative. If you're a good data scientist, of course you use data that's appropriate and representative. I mean, you want to have a good model in the end, right? Also, with GPAI, even Article 55, the toughest rules, let's say, in the AI, you need to have adequate cybersecurity. Well, that's a given. In the current geopolitical context, if you don't have adequate cybersecurity, you're done. You're toasted, right? Plus, you need to red team your model. Like if you're a major AI developer, you do evals and red teaming anyways. So that's not a big deal, actually. So the reality on the ground is that if you are a company that's kind of well equipped with compliance resources, you can handle that fairly easily. You can do this. And the AI is better than its reputation, but the narrative has gone really awry, which is why now in the US people are saying, it's killing our companies, blah, 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 which of course is it's not killing Meta, it's not killing OpenAI. But, the narrative has been evolved in this way, and this is bad for the European investment space, quite frankly.
That's a serious answer. I am a little bit conscious of time, Philip. So you know what we're going to do? We're going to finish off this section with a question, which I think is going to answer a lot of the more recent questions I've seen come up in the chat. So I will get to more questions in the chat before we finish. But the final question, I guess, for this section before we go on to our current hot topic is, really, I know you're an expert here, and you're doing a lot of close work with the EU Commission on the AI Act. So if you could tweak the EU AI Act, if you could see what would come next and how it's going to develop, what would you change to make it, I guess, more practical? And I guess that's the first part of the question. What would you do to make it more practical?
Yeah. So I would do two things. So three things. First off, I would have two things cannot be done anymore. I would have, before it got enacted, I would have paired this with an investment offensive. Just like the 200 billion Invest AI initiative, that should have been announced exactly the same day the AI Act was finished. Because we want to send the signal, we want to have responsible AI. We don't want AI just for AI's sake. But we also want it because we need it in Europe. We have a crazy shortage of skilled labor and everything. My sister works in a hospital. It's like they have no staff there. It's a fantastic, one of the best hospitals in Germany. But literally, they're doing nighttime shifts crazy on. If there's anything to take off their shoulders, if it's well done, then please do that. So one thing. Second thing is guidelines. Guidelines should have been prepared as the AI Act was published and not now scrambling. I'm not blaming the AI office. They have just started. They didn't have any people for it, but that should have been planned differently. You need to give people the idea of what the law really means at the moment in which it's out, because right now people just feel insecure. They have no idea what is coming. Third point, going forward, I think, so the Commission apparently wants to do a fitness check of digital legislation, including the AI Act. Like, what can be done about it? I don't think it's going to be scrapped. That would be too extreme a measure. And frankly speaking, I don't think it should be scrapped. Think about some of the minimum protection rules for, state-sponsored surveillance, AI-based biometric surveillance. If you want the Chinese model in Europe, be my guest, but I don't want it. And I think it's fairly good. It's very good to have that. But at the same time, some of the high-risk rules are really too pedantic, I think, and they might be too cumbersome, particularly for SMEs. So we might see my suggestion would be to say we go a little bit more on the risky side with high-risk use cases, some high-risk use cases where you say, particularly for SMEs, maybe they don't apply it not in the same manner anymore, but rather what we have is a liability regime, which is, by the way, exactly what the ALD would have been about. So we have a liability regime already in place, the PLD, product liability. And liability means, as a company, you can do it as you please, just make sure that at the end, nobody's harmed, right? And so it's less prescriptive as the AI Act, less documentation, but basically you still have to document reasonably, because if something goes wrong, you need to convince the court that you were reasonable. But you have your own ways of doing it. You have a little bit of moral leeway. And I think that could be something where I would see, a positive evolution of the AI.
Good take. So maybe those are the next steps in time. In the polls, we have just asked you also what the tweaks you would make to the EU AI Act. So choose from one of four. And Philip, I think you'll be interesting to see how this is lining up with our audience. Just to follow up here from our side, at Vendit, we're always talking about compliance, right? The regulations and the laws are there for a reason, but the easier it is to comply with them, especially from different size of businesses, the easier that the industry will be able to adapt, or any type of industry or business will try to adapt. So are there specific fixes that you see when it comes to making compliance easier, especially in the early stages as businesses and governing bodies try and coexist together?
Yeah, so I think there's maybe three things I want to point out. So the first is trying to use explainable AI or interpretable AI models instead of black boxes, if you can, because that just makes life easier for everybody. Second is be proactive in the sense of getting even if you're small, get one compliance person on board and integrate that person well with the tech team. Even if you're an AI first company, it makes sense to have one person that takes this on board, that takes it seriously, and that can then liaise to both perhaps the external lawyers, compliance companies that you hire, and your tech team. It needs to be well integrated. It cannot be the case that the tech team basically finds this great way of designing a new whatever LLM architecture, but it turns out the data that they need for it, they just cannot use it on the GDPR, for example. That would be really a waste of time. So integrated well from the beginning, compliance by design. Same with the authorities. It often makes sense, if you have a doubt, to get in touch with them, because many of the authorities, data protection authorities, now that might vary from member state to member state, but oftentimes they try to help because they don't want to penalize people. And right now, particularly, there's a strong feeling within the AI office also at the European level that we want to make the AI Act a success in the sense that it does not hinder innovation, at least not more than necessary. And so if you have a question, try to get in touch, because bilaterally, it's often easier to resolve this than waiting for something to happen. It might be that you're never contacted, you're just fine. But if then people find out, you're in a much worse situation than if you proactively stepped up.
Absolutely, and really clear. Thank you. We have just 10 minutes to go, so I'm going to quickly move on, Philip, to our hot topic. We'll give you the license to talk a little bit about this beyond the question, obviously. But every time we talk about a theoretical discussion like this and concept from your perspective, we try and put that into something that's relatable to today's hot topic. So we want to look at DeepSeek and what does the DeepSeek case at the moment reveal about transparency issues in AI for you? What's the learning there from your perspective?
Yeah, that's also, I mean, it's a super hot topic, and it's a super important one at that. Why? Because it shows us what I would call the 4 dimensions of transparency here. What are they? So the first one is certainly the privacy policy. Because if you look at DeepSeek's privacy policy, this is so bad. I actually looked at it and I thought, Jesus Christ, like my first semester students would have been better at drafting that policy. I don't know, they probably someone didn't care, I don't know. But the problem is, if you start out with such a bad privacy policy that's super imprecise, they just say we're sharing with partners. That's a no-go. You have to say what the partners are, right? They also say that they're collecting data on the way you type and stuff like this, which is of course can be quite sensitive. So that's just an invitation for any data protection authority to whop you over. So that's the first dimension of transparency, privacy policy. Second one is corporate policy. So how do you respond when, push comes to shove? Now, DeepSeek apparently shut down. They didn't really say much. They, as the Italian Data Protection Authority said, that answers were wholly inadequate. Basically, they said the GDPR doesn't even apply. Well, again, you don't even have to be a first semester student to know that GDPR applies if you're offering stuff in the EU. Is this available in the EU? Yes, it is. So, I mean, it's as simple as that. So, so corporate policy is the second. How open do you want to be in your culture vis-a-vis the outside? The third one is obviously technical. And that's something we've discussed before. And DeepSeek being a reasoning model, I suppose, is a highly complex engine, let's say, and it's certainly tough to build transparency into this. And I fully see the technical challenges behind it. And I think that we have to find a way to make sure that there is a way in which even Gen AI can be compliant under the GDPR. It cannot be the case that GDPR actually blocks all of Gen AI out of Europe. Basically, what I guess you have to do is you have to be able to, on the one hand, maybe get a feeling of what drives particular individual outputs, and then by doing testing, like maybe do 10,000 queries. And average over them and see, what's the general behavior. And of course, not going to give you a full picture, but at least perhaps an adequate picture, because what you need to give is meaningful information, right? It's not full information, not full disclosure. And by the way, the courts also said you don't have to disclose the algorithm. So basically meaning the model. So you don't have to disclose neither the learning algorithm nor the model. It's just the features and the key features and the salience of these features that you have to disclose. And the fourth one, beyond privacy policy, the corporate culture, the technical aspect, is the political aspect of transparency, because that's something that is really at stake at DeepSeek, right? When you have when you use the API, the data apparently stored in China, and we know from the TikTok proceedings in the US before the Supreme Court that Chinese government has access to basically all of the data, or can request access to data from Chinese companies. So basically, the data is in the hands of the Chinese government, and I mean that's a very individual decision everybody has to take. But I'd be very careful about what I disclose to the Chinese government. Having said that, I mean it also needs to be said that of course the U.S. companies are subject to U.S. laws, and NSA and other authorities from the U.S. government can also look at the U.S. companies side. And with the worrying developments that we have in the U.S. at the moment, basically you have to choose your regime that you want to, your government that you want to be able to look into your data. Which is why, at the end of the day, oftentimes, particularly for businesses, it's best to really do this locally and deploy it in a secure environment, and to just run the local models. You're not sharing it with the outside world, and that's probably the gold standard for now.
Yeah, I think you bring up four very interesting points here. The last question here, very quickly, is so like based on what you've just said there, should transparency be standardized, or will national interests always shape AI governance? How do you see it?
Well, I think, frankly speaking, it should be standardized. I'm personally a big fan of international standardization, because it just offers one set of tools, a passport. You comply once and you passport it across the globe. That's great. I think it's good for businesses. It's good for consumers. They know what the regime. I mean, they don't personally know, but they could know, and consumer agencies know what the regime is. But at the same time, I'm a bit skeptical in the current atmosphere that we have internationally that we're really going to have an international agreement about it. But there is standardization efforts going on nonetheless. For example, Senelec, which is a standardization organization in Europe, they are working out the standards for the AI Act. And if you comply with the standards, with these standards, then there's a presumption that you're in compliance with the AI Act. And it'd be great if, and there's international, like ISO and other organizations also worldwide that are working on AI standards. You have the NIST risk management framework. And basically, if you take these together and distill something for transparency, something for bias and non-discrimination, something for copyright, something for the environment, something for quality control, then you go a long way towards facilitating really international trade, international services, and so on. And I think that would be to the benefit of really many.
Yeah. this is a lot of information. Philip, I think we could do another 3 sessions and still be just getting warmed up, and B,
be my guest,
engaging with your audience. So first of all, I think I will take the time as we approach the hour to say thank you very much to yourself. I know we had a good chat yesterday, didn't we? And I just love your personality and making things jump off the page that might be technical. You've got a really great way to really shine a light on them and engage an audience. And secondly, to the audience that joined today, many of you are new to myself and to Vendict. So it's great to see you, and it's a really great audience to be a part of. So thank you for joining today. Just a couple of things to remind you of. We will send the recording out to everybody who's joined and everybody who couldn't make it. So you'll receive this recording in your inbox. It will be great to talk to you, some of you, more about what type of webinars you're interested in, and we'll try and get Philip back as soon as possible. He's a very busy man, so hopefully we'll get you back for a second round, because I think it's very much needed. And really appreciate all of your time today, and enjoy the rest of your Thursday. So thank you very much, Philip. Appreciate it.
Thanks to you. Thanks, James. And thanks to the audience. Really great, engaging audience. Thanks for all the stuff in the chat. A lot of funny and really interesting comments. And I'd love to pick up more of them as we perhaps iterate this another time. I'd love to come back on stage with you.
Thank you, Philip. Take care. Have a good day.
You too. Bye-bye.